Amen. Thank you, preacher. Okay, we're here for a hearing on House Bill 750, House Bill 809, and House Bill 824. And looking at the authors, I believe the fellow longest in the tooth and with the most seniority in this group would be Chairman Smith. Are you ready to present your bill? All right, well, proceed, sir. Up here probably. I think they like to do that because of the recording and the cameras and whatever all.
Is it because I have seniority or I'm just old?
Yeah. Whichever makes you feel better.
Thank you, Mr. Chairman and members of the committee. I bring to you House Bill 824. House Bill 824 clarifies that a variety of routine fees for banking services offered by state chartered banks and credit unions will not be considered interest. The bill covers a range of common deposit account fees, including overdraft fees that are agreed to in writing between the depositor and the financial institution. The bill simply confirms the law that we have understood for a lot of years. Deposit account fees are in fact fees, not interest. Now the next statement I want to give you is really important. It says, the bill ensures banks and credit unions operating with a charter issued by the state of Georgia are treated the same as banks and credit unions operating with a charter issued by one of the federal agencies or other states. Fees charged by these federally or state chartered institutions are not considered interest under federal laws or any other state. Federal laws and rules expressly state such overdraft fees and other deposit account fees are not interest for those financial institutions operating in Georgia with a national charter. The bill removes any ambiguity about these same fees for Georgia chartered institutions. The bill creates parity between state chartered and federally chartered banks in Georgia. In other words, House Bill 824 creates a level playing field. In July of 13, Commissioner Hagler issued a declaratory order stating that overdraft fees are not interest. The order applies only to state of Georgia chartered banks and credit unions, and the Commissioner can issue parity orders based on 7-1-61 of Georgia Code so that state chartered and federally chartered banks operate on a level playing field. Now, in conclusion, without this legislation, families and businesses that have chosen to do business with state chartered institutions may not have access to these services they have become accustomed to. House Bill 824 is needed to assure that Georgia chartered financial institutions do not have to operate at a competitive disadvantage. Another important point, no other state in the country has these restrictions, and neither should Georgia. Point of interest, of the 159 counties, 59 of those have no federally chartered banks. Mr. Chairman and committee, I ask for your favorable consideration of House Bill 824.
Thank you, Mr. Chairman. Do we have any questions from the committee for Chairman Smith concerning House Bill 824? Just press your button if you're not in rules. I don't know how that works. No questions for Chairman Smith on that. Oh, I'm sorry. Mr. Flood.
Thank you, Mr. Chairman. Chairman Smith, just so I understand the intent of this bill. Right now, federally chartered banks and credit unions do not consider overdraft fees as interest.
Correct, that's federal law.
And essentially what we're doing is making sure that those institutions that are chartered by the state of Georgia are treated exactly the same.
Yes, sir, you're exactly right.
Any further questions? No more questions for the chairman. Give me just one moment. I had asked the author of the bill, due to some scheduling. Now, we had said prior to this meeting that we were not going to vote on a bill. And if there's objection from the committee, we will postpone the vote until tomorrow on House Bill 824. But I would ask the committee to consider voting on that bill at this meeting. But I would ask if there is objection. If there's objection, we'll vote tomorrow like I had said we would. Is there any objection to voting on House Bill 824 today? No objection. Okay, well then we will, if I have a motion.
Mr. Chairman,
Do pass. Is there a second? Is there any more discussion, any further discussion? Those in favor of House Bill 824 will signify by yes by saying aye. Aye. Any opposed, no. The bill has a do pass recommendation.
Thank you, sir.
Mr. Chairman.
Thank you, committee.
At this point, I will recognize the Vice Chairman, Representative Williamson, to present House Bill 809. Vice Chairman Williamson.
thank you, Mr. Chairman, members of the committee. Today I bring before you for your consideration House Bill 809. This bill would amend our Fair Business Practices Act of 1975 to prohibit the bad faith assertions of patent infringement claims. Well, when I first got in the General Assembly, my good friends always, on both sides of the aisle, asked me the first question I would hear is, what's your bill do? And what I'd like to tell you today is why we need this legislation, and then I'm going to tell you what it does. But for the last several years, the nation has seen a proliferation of patent infringement claims. These are commonly called patent trolls. It's sort of a derogatory term, but according to Investopedia.com definition, I'm going to quote what this means. This is a derogatory term used to describe people or companies that misuse patents as a business strategy. A patent troll obtains the patents being sold at auctions by bankrupt companies that are attempting to liquidate their assets, or by doing just enough research to prove they had the idea in the first place. They can then launch lawsuits against infringing companies, or simply hold the patent without planning to practice the idea in an attempt to keep other companies' productivity at a standstill. So that is this definition of what a patent troll does, but how do they operate? These patent trolls actually assert claims through vaguely worded demand letters that, and what they were hoping for is a quick settlement with the businesses to whom they're targeting these demand letters. Small businesses are particularly vulnerable to these tactics due to the lack of financial and legal resources, and more often than not, they feel forced to settle. So, the next thing I would want to know, had I not researched so much this bill, is, well, give me an example of our Georgia businesses being effective. And anything that's happening in Georgia, you can multiply it by 50 because it's happening all across our nation. So in particular, Georgia businesses have received letters and emails, which the demand letters are oftentimes sent in the form of an email. And they're demanding that our Georgia businesses pay a license fee for technology that they're currently using. Sometimes it's for as simple as converting an incoming fax to an email attachment. Another example, and it affects businesses that I've invested in, that demands a number of our small community banks pay for a license fee simply to cover the way that covers the way their ATMs are connecting to the internet. So the demand letter is alleging, in this case, of community banks, and it could equally affect our credit unions in Georgia, that because of the way these ATM machines are physically going into the internet, there's some sort of technology going on that the bankers wouldn't be aware of, or the credit union board of directors wouldn't be aware of, that is allegedly being infringed upon by the way this process works. One industry that during my research is particularly hard hit is the digital printing industry in Georgia. It turns out that owners of these patents are alleging infringement covering these quick response codes, these QR codes, the little funny looking, little puzzle looking things, square things. As my kids have sort of educated me how they work, but they're on almost all of our products and things we buy in the stores now, and oftentimes the printers, or at their customers' request, are putting these QR codes on merchandise. And then in turn, our high-tech digital printing industries are getting hit with patent assertion claims that, or assertions of patent infringement claims that the codes they're using, the scanning, the computer-to-plate workflow that the printers are doing, and their online ordering systems are infringing upon patent holders. Well, almost inevitably, they're vaguely worded assertions. And what this legislation would do would attempt to stop the bad faith assertion of patent infringement claims. Would in no way, shape, or form stop any legitimate patent holder from protecting their intellectual property or those processes or technologies or parts or whatever that they've invested in the product, patented it, and would no way, shape, or form stop their ability to protect their patent. One thing I wanted to point out was that most of the targets of these patent infringement claims are small businesses. We're talking about $10 million of revenue and below, down to the mom and pop hardware stores on Main Street. One Boston University study showed that 90% of the companies sued by patent trolls were small to medium-sized technology companies, and they estimated that $29 billion in patent claims were incurred in the year 2011. And the problem's only gotten worse in the last 3 years. So, real briefly, Mr. Chairman, if I may just walk everyone through the bill line by line. Well, not every line, but just going to skip to the highlights. So, this legislation shows in line 25 that a person shall not make a bad faith assertion of patent infringement. Now, a court's going to consider what a bad faith assertion is in the demand if the demand letter fails to contain the next three lines I give you, which is line 29. The assertion's going to have to include the patent number. The assertion will have to include the name and address of the patent owners or assignees. And in line 32, the demand letter is going to have to include the factual allegations that are concerning the specific areas in which the target's products, services, or technology have been infringed. In lines 34 through 37, you'll read that if the patent owner fails to conduct an analysis comparing the claims in the patent to the target's products, services, and technology, they will have to specify in their demand letter how the target, the business is getting sued, is actually violating the patent. And none of these demand letters are doing that now. They're just vague assertions. Again, it's fishing expeditions by these patent assertions entities that are trying to milk money out of legitimate businesses, basically through a series of intimidation letters. Now, before I conclude, I want to stress that this in no way, shape, or form stops the legitimate protection of patent holders. In fact, lines 64 through 65 says very clearly, the author of the demand letter is not going to be considered a bad faith claim if the author of the demand letter makes a substantial investment in the use of the patent or in the production or sale of a product or item covered by another patent. In lines 66 through 77, it's not going to be a bad faith claim if the author of the demand letter is actually the inventor or original assignee of the patent. If the owner of the patent is an institution of higher learning, and folks, that's what our Georgia institutions are all doing. They, when a process or technology comes along, and anyone, I won't start naming them because I'll miss somebody, and I don't want to do that. But if the idea bursts out of a Georgia institution of higher learning, and it is something that the university chooses to patent, that's protected, even if it's sort of parked for a while, because that is research that's derived from a university that is not going to be a part of any kind of bad faith effort. It would be, by the definition under this bill, would be excluded from any bad faith allegations. And finally, any businesses that are asserting a patent infringement claim, if they've previously demonstrated good faith business practices in efforts to protect their patents, they're going to be excluded from a bad faith action. So at the end of the day, the court's going to decide if, in fact, the court looks at these series of steps that we're going to require, that hopefully we will require through the steps in this bill, that if it is, in fact, if the target has sufficiently convinced the court that they are the subject of a bad faith patent assertion claim, then the court at that point in time could make the patent holder put up to $250,000 bond to cover the legal defense in the event that the target is in fact held to be innocent of the claim. And what we believe, and other states believe, is that by putting these bad faith steps in, these high bar for these folks to hop over, that it will stop this, quote, patent trolling and this extortion racket that our businesses are falling prey to. So with that being said, Mr. Chairman, I'd be happy to answer any questions the committee might have.
Thank you, Representative Williamson, and we will do that right now. If there are any questions, Representative Smith, I believe, has a question right out of the chute.
Thank you, Mr. Chairman. Just have two short questions.
If you'll push your button, Representative Smith, and use that, I think they, again, like for us to use these things when.
Got to push it on the desk.
There you go.
Okay, I'm live now.
You're live. You're in room.
Thank you. Just two brief questions. Under Article 20, well, how you doing first?
Fine,
Good.
Representative Smith.
Thank you, thank you. Under Article 27A, going over to the second page, numbers 29 through 52, do we have anything on record, or is this the first that we've seen of this, or is this the actual record of what is on the books now for these patent infringement opportunities?
No, this would be brand new for our Georgia code. What we'd be doing is this would be actually amending the our Fair Trade Practices Act of 1975 to include, which is would be in this legislation would be administered through the Governor's Office of Consumer Affairs, where you see the Governor's Office of Consumer Affairs is handling other bad faith type business practices. That's why this doesn't have anything to do with patent law in particular. We're talking about identifying people that are bad actors, applying, implementing bad faith. I can't have to use the terminology in the bill is just bad faith assertions. Because they're going, all they're doing is going on a fishing expedition. They really don't want to end up in court. They want to sort of terrorize a small business owner, get some licensing fees if they can, or settle quickly. The fees that ATMs were getting hit for by some of the financial institutions up in the Northeast was anywhere up to $5,000 per ATM. Well, a little regional bank that might have, 50 ATMs, that's a significant hit to their bottom line.
Because this is pretty significant. So there's nothing on the books pertaining to this, 29, 28 through 52?
No, sir, not to the best of my knowledge.
And the last question, number 98, exemplary damages, would they be deemed as being punitive, or I'm trying to get a differentiation between exemplary, is this punitive, is it exactly what is this?
I'm going to have to defer to some of my legal colleagues there, Representative Smith. I do not know the answer to that question.
Okay, thank you.
Okay. I'm sorry. Representative Strickland.
Thank you, Mr. Chairman. Representative Williamson, I have one question. The motion that's referenced in paragraph 79, help me understand, that motion would actually be filed in an action for patent infringement. It couldn't be filed just when you get a demand letter. You couldn't go file a motion with the court at that point. Is that correct? It would take a demand letter and then an actual patent infringement case. The motion could be brought in. Am I understanding that correctly?
I would, again, Representative, you're an attorney and I'm not, but I'm assuming that's the legal steps involved.
Okay.
At the end of the day, as a business guy trying to explain to attorneys those steps, I'm not very good. But what this does, as I've been assured, is it sets up the mechanism to stop the bad actors, thereby protects Georgia businesses.
Okay, thank you.
Who are we looking at? Representative Frazier, you have a question?
Yes.
There you go.
Thank you, Mr. Chairman. Representative Williamson, can you give me some stats on fees that have been charged in the past that warrants this bill? Because you have had to have someone talk.
Some examples?
Yeah.
And
I'd like to know the cost. I mean,
yeah. Well,
what is the savings?
again, according to this study done by Boston University, the cost back in 2011 was, in fact, according to Boston University's estimate, and I'm sure there were legitimate patent infringement claims in this bucket of money, but it hit $29 billion was their estimate, billion, in 2011 out of the because of business litigation claims. So this truly is a bipartisan issue. Vermont, this is based on National Council of State Governments legislation. Vermont just passed this. Our friends out in Nebraska are passing substantially similar legislation. It's my understanding that this very, very similar legislation is working its way through 13 additional state legislatures right now. It's just reaching almost a crisis proportions the way these claims are hitting our businesses. So, but speaking back to, I was trying to give some examples of how Georgia businesses are being hit, but again, as far as ATMs, anywhere from $2,000 to $5,000 licensing fee per ATM location. And these letters never tell you exactly what you're doing wrong. You can't fix something that when it's just a vague assertion. So they threaten the small business that, hey, if you don't send us this money, we're going to sue you. Well, then the business owner goes to their attorney, and the attorney says, I think you can win this, but it's going to be a lot more than $5,000. You might as well pay them the $5,000 and make it go away rather than go to court and incur substantial legal fees.
Thank you. Do we have, Mr. Chairman, do we have any, I'm hoping that we have someone here that can testify to some of these fees. I'm very interested. You're not able to give me
We have several
amount.
speakers of the bill.
Yeah.
Right.
Toward the bill, if you want to.
Am I misunderstanding your question, Representative Frazier? Because when you say fees, these are demand letters that various businesses are getting, and it could be $1,000 per scanner in a business, or set amounts for another process that might be going on in the business that they're alleging that they have a patent on. And again, all our legislation is doing is when that demand letter comes to the business you represent over in Burke County, or it's Burke County, right, and others, surrounding counties, when they get this demand letter, it's got to say who owns the patent number, who owns the patent, how to get in touch with them, and specifically, what is that business doing to infringe the patent? Now, you've got Vogel over there. They've got enough money that they can just hire a bevy of lawyers and steamroll them, but the high-tech farming operation over there might be getting a demand letter because of the kind of technology they're using in their broiler houses or whatever, and they're not going to have the money to fight it. And that's indicative of the kind of, they'll roll in with a very vague patent and just target industries all throughout the country, and Georgia businesses are beginning to hit. They're strategic in the way they do it, and I've read a lot of articles substantiating the information I'm trying to share with you. They'll go into community banks in this area, and not in Georgia and South Carolina at the same time, but they'll skip from Vermont to the Midwest to Georgia, because they're trying to run under the radar before a lot of similar businesses get together and fight them as a class action, for example. So, but yes, the chairman's correct. We do have some expert witnesses here that would be happy to share some
Okay.
help, hopefully answer some more of your questions.